Welcome to We Chat Divorce, hosted by Karen Chellew, Legal Liaison, and Catherine Shanahan, CDFA. Each episode, we sit down with divorce professionals and industry experts to provide insights and frank discussions about real people, real situations, and real divorce to help you achieve your best life post-divorce. This episode of We Chat Divorce is brought to you by My Divorce Solution, offering divorce financial planning so clients can secure the divorce settlement they deserve. Visit mydivorcesolution.com to request access.
Most people think divorce spins out of control because of conflict. What we see here at MDS over and over again is that it spirals when people believe they have no say in the outcome and hand decisions over to their spouse or to their attorney or mediator far too early. Welcome back to We Chat Divorce, brought to you by My Divorce Solution. I'm Karen Chellew, Legal Liaison, helping you understand the legal side of divorce so you can move forward with clarity instead of conflict.
And I'm Catherine Shanahan, Certified Divorce Financial Analyst. And at MDS, we believe preparation is what restores control, financially, legally, and emotional. I help you understand the financial side of making permanent decisions from a place of fear, rather than a face of knowledge.
After recording today's conversation, one thing really stood out to us: how much calmer and more manageable divorce can feel when people understand that they actually have options.
You know, Karen, sometimes you think you have options, but you don't have options. So if you want an uncontested process, great. If your spouse doesn't cooperate, guess what? It becomes contested. So some things are actually out of your control, and a lot of things are actually in your control. And I think it's really important to know the differences between the two. Even our clients that come through our process, right? They always say, oh, my spouse, he won't participate, or my spouse, he's a narcissist or very high conflict, so they won't participate. So you think immediately you have to go get a pit bull attorney or something, right? And then when we move through the process and give the spouse the opportunity to participate, more often than not, they do. And whatever participation you get from a spouse is good participation, because you'll get information for free, basically, rather than having to go through the whole subpoena process for some of that information. But I think this conversation just really points out, and I know she's from New York, so if you're from New York, you'll like to hear this podcast about contested and uncontested divorces, but really how you are in control, because everyone works for you if you're going through divorce.
Yeah, that is so true. And, uncontested divorce mediation really can only work when you're prepared. Everybody likes the idea, the concept, right? Everybody can adopt it, but it can't be successful unless you prepare and you know the impact of your decisions. And that's, why we exist. That's why My Divorce Solution exists. So you can have that knowledge and you can make very good informed decisions.
Mm-hmm.
So we're looking forward to sharing this episode with you. We sat down with Renee, a family and matrimony attorney and the founder of Thoughtful Lawyering, to talk about what uncontested divorce really means. It's important that we all know, and why it can be such a powerful option for the right families who are prepared. So if you're wondering whether there's a way to divorce with less conflict, more dignity, and greater control, this conversation is for you.
All right, let's get into it and share our conversation with Renee Turner.
Welcome, Renee, to the We Chat Divorce podcast. We're so glad to have you here with us today.
I'm grateful to be here. Thank you.
I think this is going to be a great conversation about uncontested divorces. Everyone who's getting a divorce, I would think, would love to go this route. So before we get started, for our listeners, Renee Turner is a family and matrimony attorney in the state of New York and the founder of Thoughtful Lawyering. Her work centers on guiding clients through divorce and family transitions with intentions, especially through uncontested divorces, parenting plans, and prenup and postnup agreements. Renee helps people slow the process down and understand their legal options and make decisions they can actually live with long after the divorce is final. before we get started, Renee, can you briefly tell us what brought you to doing this work that you are doing in New York, which is quite unique from what I could tell on your website?
Yes, of course. So I've been a practicing attorney for over 13 years now. I started my career as a judicial law clerk and then moved into what many people know as big law. I spent 8 years at a top New York City law firm as a corporate litigator, but during that entire 8 year period, my pro bono practice was focused on helping survivors of domestic violence navigate their divorces and custody disputes. And that work was incredibly meaningful to me. Towards the end of my tenure as a corporate litigator, I really wanted to do more meaningful work and really work one-on-one with clients on a personal level. So I decided to start my own practice, which is thoughtful lawyering. And I really try to take a holistic approach to family and matrimonial law. I try to guide my clients carefully through the process so that they understand what the law is, what their rights are, and what their options are. And I find that if there's a supportive and transparent process, that it really empowers my clients to make informed decisions that are beneficial for themselves and for their entire families moving forward.
Wow, that's really wonderful. And I'm seeing or observing that it came out of you being in big law. And from our experience with our clients in New York, the court system is just saturated and really hard to navigate through, which causes even more conflict and adversity just because of the court system being so clogged up, as they call it.
Yeah.
I'm sure you experienced that as well.
Yes, I mean, several of my cases that were in the court system took years to resolve, and it's just because of the scheduling. The judges are very busy. They have incredibly long dockets, which is the number of cases that they are attending to, and so in terms of scheduling, it would be months before the judge could hear the case, and if there had to be several hearings, then it could take years.
Yeah.
How do you push forward someone when you wait those months to get that judge's meeting and then the other side doesn't come up with all the disclosure information?
So I mean, my approach was always to call it out and to ask the judge, so filing a motion to compel or to issue some kind of sanction, which would be that if they didn't produce it, that they wouldn't be allowed to use that information at trial, or to assert some position in the case moving forward.
Hmm. Unfortunately, a lot of times the party who's disclosing everything is the one that's waiting for the other information.
Yeah.
They need the other information to make their decisions. And then I see them waiting all these months and they get there and the other side still hasn't produced the documents.
Yeah. And I think in that case, you're hopeful that you have a judge that will be strict in terms of taking it seriously, that the other side is not cooperating, and put some pressure on the party as well as the attorney, because it's really the attorney's job to get the information, but not all clients are compliant. But if the judge, imposes some sanctions, then I think that they do something about it.
Hmm.
I think you make a good point there, Renee, and we are going to get into the uncontested process, but it is common for us to hear that people believe the judge is going to make all these determinations based on their story, and they don't understand the attorney actually has the tools to give to the judge for the decision that they're all looking for.
Right.
And I find it's a very common misunderstanding that the clients have, that the judge is going to rule relative to the story and not the actual facts the attorneys are presenting.
Right. Very true.
Yeah. So let's hop over into the uncontested divorce, and let's just start out with, in the state of New York, what does uncontested divorce mean from a legal perspective?
Okay, so in New York, there are two processes for divorce, uncontested and contested. And uncontested simply means that both the spouses are able to reach an agreement on all major issues involved in their divorce. So that includes property division, child support if there are children involved, alimony, or in New York it's called maintenance, any parenting time or custody arrangement. So that's physical custody and legal custody. And those decisions are obtained between the spouses without asking a judge to ultimately resolve any disputes that they have. Whereas a contested divorce is one where one or more of those issues are in dispute and they cannot be resolved by agreement between the spouses. So the judge has to step in, or the parties are asking a judge to step in and resolve it. But it involves, like we were just talking about, formal discovery. So asking the other side to produce documentation or answer questions. There may be motion practice, for example, like I said, the motion to compel, and then hearings before the judge, and sometimes a trial if ultimately there can't be a decision reached.
Mhm. So do they file then for divorce after they reach a decision, or do they file uncontested, hoping they reach a decision? How is that accomplished?
So typically, my process and how I've seen other attorneys approach it is that we will negotiate what's known as a marital settlement agreement in advance of filing the divorce action. Sometimes attorneys take a different approach so in New York, the attorneys, we have an electronic filing system and we can identify when we're initiating the divorce through the court system, whether it's going to be uncontested or contested. If we flag it as uncontested, then there's no pressure from the court to move along the process. We also do not have a judge initially assigned to our cases. We have to request for judicial intervention before a judge is assigned. But the best approach is to try to reach a settlement with the spouses prior to initiating the court process. And then once the court process is initiated, then we can request the judge, but we've already filed all the required documentation that's needed for the judge to review and approve the divorce.
Let's talk about maintenance, as you call it. Some people in some states, you'll hear it as alimony, spousal support, maintenance. It all means the same thing to me as a financial person. However, New York, as you just identified, calls it maintenance.
Yeah.
New York also has a cap of
Yeah.
income. Can you explain what that actually means? Because it's very frustrating to sit back and say, okay, I've been married for 25 years. My spouse makes $1 million a year. We have 4 kids. I stayed at home. I raised the kids. And now you're telling me you're going to cap out what my maintenance should be. How
So
do you come to the number?
So there is a cap, but it's important for parties to understand that the cap is so judges have discretion, and also if you decide to go an uncontested process using either attorneys negotiating or a mediator, they can discuss the fact that the income is above the cap and that the standard of living during the marriage was based on that higher income, and therefore the amount of maintenance should be based on the higher income as well. So New York is a huge state, right? And so there are different areas of the state where the cost of living is much lower than, let's say, New York City. But if the couple lives in New York City, obviously their standard of living and the cost of living is a lot higher. And so a judge can take into consideration where they live and their cost of living and the fact that the other spouse was earning more than the cap, as well as the parties when they're negotiating.
How do you figure out how much over the cap to go? You base it on their lifestyle analysis?
Yes, exactly. So you would do a last sale analysis. In New York, we have a statement of net worth, which is required for each party to complete, and it includes their expenses. So you would have a understanding of how much it costs your client to live the life that they've been living as a married couple. And also, it's really good to try to do a budget. So your life is going to change after divorce, but if you're able to identify what your needs are moving forward when the relationship has ended, or if you already separated, then it gives you a good baseline in terms of figuring out what the maintenance amount should be.
Yeah, it's always an eye-awakening experience. It's the first step we take with our clients is to do that lifestyle analysis.
Mhm.
Um, it's a tedious, difficult task for most people. And
Right,
I think the realization of what your need actually is what gets to you.
right.
Yeah. Well, I really appreciate the fact that, we're here talking today about the uncontested divorce because it marries very well with the MDS process. But before I go into that a little bit more, Renee, in the uncontested process, what is the disclosure of documents? And maybe every attorney may be different, but for your practice, do you have some mandate for what documents get produced to support the marital estate? Or do you just take what they give you and do the negotiations or analyses on that?
So I believe in transparency, and so I require my clients to complete a statement of net worth, like I mentioned, and that also identifies their assets, their income, so that there's full financial disclosure. Because sometimes you have in marriages like one spouse who's been in control of the finances throughout the entire marriage, and then the other spouse is blind and just unaware of what their assets are or what they have as an entity as a married couple. And so I always ask for that. And then so I have had cases where I've gotten pushback in the other side. So in New York, it's if there's an uncontested process, there's not a requirement for a statement of net worth. But at least I want to see the tax returns. There has to be some financial documentation so that I can advise my clients. In what is, I guess, beneficial for an uncontested process is that the parties themselves can waive um, full financial disclosure if they're comfortable in and have made informed decisions on what they're waiving. So if a client comes to me and their spouse says that I'm not producing a statement of net worth, but my client says, I know exactly what my spouse has, I know what I would be waiving, then we can have a conversation. But I really try to encourage that they get as much information as possible.
Yeah, I appreciate that you say that because we feel that we have so many people coming through and they start on the premise of, I know what I have. And then when we start the work of, okay, that's great. Let's start telling us what you know and what you have. And often, probably 90% of the times, there's nuances or facts that they hadn't even considered. And
Hmm.
so by going through the process of supporting documentation to the assets or debts gives them clarity about what that pie is so that they can feel really confident about going into the uncontested process and waiving that financial disclosure.
Right,
So I appreciate that that's available to people, but also, and I'm sure you recognize too, that some people believe they know, but they only know what they know
what they know.
until
Right,
someone's starting to unpack it with them and saying, well, did you know about this and the impact in divorce? Because it's very different than a net worth statement.
right, exactly.
Let's
Well,
take
not
that
a statement of net worth. I,
well, let's take
yeah.
that couple of uncontested divorce I just love how a party would say, I'm not giving you my net worth statement, because that to me would be like, okay, now I'm contesting this. I mean, I would switch gears right away. But anyway, that's me. Um, but if you are in that situation and you're uncontested and your spouse brings you a beautiful spreadsheet and you're saying, okay, I don't need the documents, I don't need, or your spouse is not bringing you a net worth statement like you all are saying, and you agree to that, does the party at any point get to say, you know what, I'm not feeling comfortable now. I want this. This is now turning into a contested divorce because I'm changing my mind. I do want that information because now I'm financially clear. I have clarity now and I want the information.
Oh, yeah, there's always the option to convert to a contested process. You're not stuck in it. If you get to a point where there's an impasse, I've had that where the parties cannot agree, then it becomes contested. You always have the option to go to court.
But a lot of people are afraid to tell their attorney that. You know,
Mhm.
they don't want their attorneys to get mad at them. They've been working months on this and they believe their spouse has done everything. I have seen attorneys come in hard on their clients saying, you really want to start this all over? So what is
Mhm.
it? What is a little checklist of, what somebody should ask themselves if they want to start over, not fearing their attorney's opinion?
Well, you need to ask yourself if you're making a knowing, voluntary, and informed decision in terms of waiving your rights, your legal rights. And if you're not comfortable that you have all the information that your that you need in order to make that decision, then I think that's when you have to question whether this is the right process for you. And I just have to say that I understand attorneys who pressure their clients to settle, which I don't agree with, because I do think that there's a process in place for a reason. And pressuring, I think if you go to your attorney and you say, I'm not comfortable proceeding with an uncontested process, I really think that we should litigate this. And the attorney comes back and says, no, you really should agree and settle. I would ask the attorney why they're making that decision, that recommendation. Is it based on the fact that you don't think that I would succeed in terms of legally under the law? Or is it a convenience thing? So, like, some attorneys don't want to put in the work, even though they get paid to go to trial, pre-trial, all the hearings that are involved. But it's really, you have to, I always encourage people to understand that when you're in a when you've employed an attorney, you are the employer, right? You're paying them. And so if you have questions and you have doubts, you need to ask the questions and ensure that you're comfortable with the answers. And if you're not, then you need to consider whether or not you need to change attorneys.
I love that you say that, because so many clients, as you know, when you probably experienced when you were in litigation, they just feel under so much pressure, and they don't realize that they have the ability to make decisions that are best for them, irrespective of the pushback they're getting from their legal counsel for a variety of reasons.
Right.
So I appreciate that you say that and you let people know that, because it's really important.
Yeah. And I have encountered individuals who have come to me after they've entered into a divorce settlement that now they regret. And for anyone listening, before you sign anything, even if your attorney is just like, you should just sign it. Don't just sign it. You have to read it and you have to understand it, because once you are out of the process, it's really hard to go back to a judge and say, I didn't understand what I was signing, when you had an attorney who was supposed to explain it to you. So make sure you're taking the time to read the document and ask questions if you don't understand.
That's the scary thing for a lot of people. And a lot of times these documents that they're getting don't come for a week, or so much time elapsed before they get the final document to review. And others are asked to sign it right there on the heel of the mediation, or whenever they're like, sign it now, otherwise this deal goes away tomorrow. So they're stuck, like, what do I do? And they're tired, and they want to be done. Like you talked about earlier, everybody wants to speed through this process if we can. So oftentimes I hear my attorney will be mad if I don't sign this.
I mean, like I said, you're the employer, so your attorney can be mad if they want to be mad. But one thing, like, I had a client yesterday who said that there's supposed to be a final mediation hearing in a couple of weeks. And she's like, I really want to have a meeting before then to talk to my attorney. I'm like, yes, and you should continue to send emails every day asking for that meeting, because you don't want to get to the meeting and then there's an agreement that you're forced to sign. You want to preview with the other side exactly what you're asking for, get their response to that, and then come to terms. You want to be able to go into the signing knowing exactly what you're agreeing to and understanding it, and not being forced to do so.
It's another one. They haven't met with their attorney until the day before
Yeah.
mediation.
No,
Yeah.
there
And you
needs
know
to be
what?
prep time.
Yeah. Divorce in and of itself indicates that there's challenges, right? So taking the step of making sure you know what you have and you have supporting documentation is really something, in my opinion, that you should do no matter what. It sounds good to say we trust each other, and maybe you do, but also as you're moving forward, or not either of you, but as people are moving forward in divorce, they're learning to make independent financial decisions for themselves. So taking the time and going through the exercise of understanding what all of these assets are and what they may mean to you post-divorce is also important as you're making that decision of just dividing the pie.
Right, exactly.
Yeah.
And I think sometimes clients don't understand that there are other resources. So, I'm not a financial expert, but I could bring in a financial expert to help explain the finances to my client so that they're clear, that they know exactly what they have and what they're giving up and those kinds of things. So I think it's really important to let them know that there are other resources, or if they are listening to this podcast, that they know they can ask if there's a certified divorce financial analyst that they could talk to.
Yeah.
Well, we all are about the preparation platform. So for us, our CDFAs or divorce financial specialists don't invest your money for you. We don't have a stake in the game, but our stake is making sure that when you hire us, you have financial clarity. And sometimes that is knowing what's missing, knowing what you do have, and knowing where you need to compromise, because everybody has to compromise. So it's really always a good lesson and a reminder that when you come in to our process and you feel so scattered or you feel so taken advantage of and just not in the know, when you start getting a little bit of information, knowledge is everything in divorce.
Right.
They say knowledge is power, but for me, knowledge is absolutely everything that you need to get through this process, which is a very difficult process. And the more knowledge you have, the better you can work with your attorney if you need an attorney through the process, right? Because you're knowledgeable. You're not just letting them tell you things that you're uncomfortable with.
Right,
Because a lot of
exactly.
times when attorneys talk, it goes over a lot of people's heads. They don't know the verbiage. They don't know what their financial situation looks like. They don't know what documents they actually do have access to. They don't know what
Right,
their bills are in their home. They've never paid their bills. They don't really understand what the cash flow is. So you end up sitting in your attorney's office helpless. So when they
right,
come through our process with your portrait, at least you're going as an informed client, and your attorney can look at that and say, now legally, this is the strategy I recommend.
right, exactly.
It's a whole different conversation.
I agree.
Yeah. And then you can confidently go into the uncontested process and not be afraid if you have to pivot over to the contested. So I like that a lot. Renee, do you provide services of reviewing prenup or postnup agreements when couples are then eventually divorcing? Because a lot of times, they're starting out with a prenup as kind of the first thing that needs to be addressed before they can go into the further negotiation. So is that a service that you provide?
Yes, definitely. If I had a client come to me and they already had a prenup or a postnup, I would review it with them so that they understand what they agreed to previously. And so not every prenup or postnup is the same in terms of drafting. So if there are issues that I think should be addressed, then we can address them. You know, hopefully by agreement with the other party, but if not, then it needs to go to court and addressed in that way.
Yeah. So would that in and of itself create a contested divorce, or would that just be a separate issue that may
So,
need to be litigated?
so going back to maintenance, that's a big one. So, in New York, parties can waive maintenance in a prenup, but there is a New York law that states that if at the time of the divorce, one of the spouse who would require the maintenance would be required to receive public assistance if there was no maintenance, then the provision is voidable, so not enforceable. And so that's an instance where if the other side's like, no, they waived maintenance, and then I come back and say, well, under the law, the spouse is required to pay maintenance because this person would be required to be receive public assistance. So I feel like those are instances where it can be negotiated. If there's something else more extreme, and maybe in terms of like property division, in New York, it's equitable distribution. Those are issues that may convert it to a contested process because um, if one party is saying that it was separate property and not marital, that would be an issue that may need to be resolved by a judge.
Yeah. So I'd like to touch on as well, Renee, the concept that the uncontested divorce does support a healthier co-parenting relationship. I'd like for us to talk about that a little bit because we fully support that for sure.
Yeah, I mean, so when you're transitioning into a co-parenting relationship, um, the goal, right, is for it to be cooperative. And I think when you initiate a court action and you're going before a judge, it automatically creates resentment towards your co-parent and harsh feelings. Whereas if you're in a more collaborative and cooperative environment where you're negotiating the terms of your custody arrangement, your parenting plan, it sets the stage for further co-parenting in that you're working together for your children's or child's best interest, right? As opposed to, I want this, I want that, and not even thinking about what is in the best interest of your children. So I do think that the uncontested process gives the parties an opportunity to help set the stage and the foundation for that collaborative environment where they're working together for the good of their children.
100%. These types of ways to negotiate divorce definitely benefits the children.
And I just also want to add, so in New York, when you start a contested process, if there are children involved, they're usually assigned an attorney that's specifically for their children. They're required to meet with the children, no matter how young they are. Obviously, young children can't articulate, but they can, just have a dialogue with the child. When they're older, they do have more substantive discussions with the children. But it's forcing your children to now be a part of your divorce, which when it's uncontested, there is not that extra layer of having an attorney for your child. And so if you want to eliminate exposing your children to your divorce in that way, uncontested is the best approach. And I also think that, if you initiate a contested process and ultimately the judge has to make decisions, the judge does not intimately know you, your children, or your soon-to-be ex-spouse, right? They don't know the dynamics of your family. And so the decisions that they're making may not be what would ultimately be in your family's best interest. But if you and your co-parent can discuss those things in a more informal context in the uncontested process, you can structure it so that it actually works, so that you're not having to go back later to litigate issues that could have been resolved up front. And you're not having a third party who has no intimate details about your life other than what you're presenting to make those decisions for you.
Very well
makes
said.
sense. And that is why Karen and I do what we do. We really advocate for the children. So if you can get through this process in a better way, I always say divorce is not what messes your kids up. It's how both parties behave before, during, and after divorce that can mess your kids up.
Mm-hmm.
So thank you for this conversation today. I mean, some great takeaways is there's a choice, everyone. You can do a contested or an uncontested divorce. And it's important to know the difference. But most importantly, you should know that your right is still to switch from one to the other. So just because you choose one route doesn't mean you can't choose to the other one. Make sure you have that financial clarity to make really good decisions for yourself. And make sure you understand, as Renee said, you are the employer to your attorney and any other professional that you use. So ask as many questions as you need to ask, because asking questions doesn't mean you're questioning somebody. It just means that you are not clear on the decision you have to make. And it's one time you're making these decisions and then it's over. You're moving on with your life and your attorneys are going on to other cases. But Renee, tell our audience how they can find you.
Sure. So my practice is thoughtful lawyering, and that's my website, thoughtfullawyering.com. I'm on Instagram at thoughtful lawyering, so feel free to reach out. I'm always happy to talk, and I do offer a 15-minute free consultation. So if you want to schedule one of those, it's available on the website.
That's excellent. And if you want to understand your own situation, your own financial situation with verified numbers, expert financial analyses, and a clear framework for negotiation, visit mydivorcesolution.com and take our free assessment to get started.
And we also invite you to join the NDS community. It's a free supportive space where you can learn, ask questions, and attend our live Q&A sessions that Karen and I are usually on and sometimes have an expert in. You'll find the links to in the show notes.
Renee, thank you again for sharing your insight and perspective with us today.
Thank you for having me. This was great.
Of course.
And to our listeners, listen, take pause, take a breath, make good decisions for yourself. And you are allowed the time to gather information before making your decisions. So don't make anyone rush you into making uninformed decisions.
Exactly. And I'm just going to add, protect your peace and let knowledge be your power. And we'll see you on the next podcast.
Thanks for joining us on another episode of We Chat Divorce. We hope this episode was informative and supportive on your divorce journey. If you're looking for more support for navigating divorce with confidence and clarity, head over to mydivorcesolution.com for more podcast episodes, divorce events, and resources for your divorce. We'll see you back here for our next episode.